Hey there, estate planning attorney Paul Rabelais here, and in this video I'm going to describe the 17 chapters that are in my book, Estate Planning in Louisiana, and just give you the high points of what's in each chapter. Not only will it give you a good overview of what's in the book, but it'll also give you a kind of a good idea of the key concepts that are often discussed when people engage an estate planning attorney and want to get their legal affairs in order, protect things for their family. So yeah, the book, it's called Estate Planning in Louisiana, 2025 edition. Available on Amazon.com. Put the link in the description below if you want to check it out. So let's jump right into the chapters, and let me give you a really quick version of what's in each chapter. Chapter 1, estate planning in Louisiana, why it's different. So Louisiana is different from all of the other states. We derive many of our estate planning laws from the French civil law. Other states, it's the English common law. So we talk about why it's different. Things like community property, things like forced heirship, which are in another chapter, different forms of ownership like usufruct that we have, again, the topic of another chapter. But I start introducing you to why estate planning is different in Louisiana. Chapter 2 is all about Louisiana community property. Louisiana is one of a handful of community property states. In community property states like Louisiana, then assets that are acquired during the marriage, even if one spouse works and one spouse doesn't work, the assets acquired during the marriage are community property, even though maybe only one spouse worked for those assets. So marriage is a 50-50 partnership. There are some exceptions to the community property rules. For example, if a spouse acquired an asset through either an inheritance, a divorce, an inheritance, a gift, or they brought that asset into the marriage, then those assets are the separate property of the spouse who either inherited or was given the asset or brought it into the marriage. One community property rule I explain in chapter 2 is that if a spouse does have separate property, for example, let's say they inherited $1 million worth of stock from their parents, and that separate property produces some income, things like dividends or interest. Well, the stock retains its separate property status, but the income that the separate property produces is community property. So a lot of married couples don't realize that. All those community property rules are laid out in chapter 2. Chapter 3 is all about forced heirship. Really doesn't apply too much. First of all, let me define a forced heir: someone who must inherit from you, even if you want to disinherit them. So a forced heir is a child of yours who, when you die, that child of yours is 23 years of age or younger, or a child of yours of any age who, when you die, is incapacitated. And there's a long definition for what incapacitated means. So looked at the other way, if when you pass away, you have a 21-year-old and you tried to exclude them from your estate, from inheriting anything, well, that 21-year-old child can then say, well, wait a second, I'm a forced heir. I'm automatically entitled to part of my parents' estate. If you have one forced heir, they're entitled to 1/4 of your estate. If you have 2 or more children collectively, forced heirs, they're entitled to 1/2 of your estate. Things like IRAs and life insurance don't apply in that calculation. And again, it really only applies if when you die, you have a forced heir and you've attempted to exclude them from inheriting anything from you. That's chapter 3, forced heirship. Chapter 4 is power of attorney. State by state, this stuff is different, but Louisiana, pretty much every adult really should have a power of attorney. Really ought to have 2 of them for the reasons I'm about to explain. Most people, when they create their estate plan, get their legal affairs in order, they'll sign 2 different powers of attorney. One is called a power of attorney, or it's called a general or a financial power of attorney or a durable power of attorney. That's who can handle, who do you want to appoint to be able to handle your money and your business and your property if at some point during the rest of your lifetime you can't handle it for yourself. Maybe you get Alzheimer's, maybe you have a stroke. Because if you get to a point where you can't sign for yourself and something needs to be transacted and you don't have a power of attorney, then family members are going to sue you in a court proceeding called an interdiction. Very complicated, very expensive, takes a long time. They're all a disaster. So you can avoid all that by having that power of attorney in place. And then, oh, by the way, most people sign 2 powers of attorney, one for general and real estate and financial matters, and then another, often called a healthcare power of attorney. That's who do you want being able to go get your medical records, talk to your doctors, make treatment decisions. If for some reason you can't make those decisions for yourself, most people on their powers of attorney, if they're married, they appoint their spouse, maybe an adult child or children as the backups. All that's laid out in chapter 4, power of attorney. Chapter 5 addresses the Louisiana intestate laws or rules. That's who inherits from you if you have no will or have no estate planning in place. So lots of different circumstances there, but the typical circumstance is the married person who dies without a will and they have children. So the quickie version is if a married person dies and they have community property, their surviving spouse keeps the surviving spouse's one half of the community property and the deceased spouse's half of the community property, while the surviving spouse inherits what's called the usufruct of that until the surviving spouse either dies or remarries, whichever comes first, and then those assets revert back to what's called the naked owners or the children of the first spouse to die. So lots of people, they don't like the way that the intestate rules would apply to their circumstances. And so that's why they engage in estate planning, to have more control and say over who gets what and when they get it and all those things. So that's Chapter 5, Louisiana Intestate Law. Chapter 6, Your Last Will and Testament, goes into all the reasons people have wills, all of the different kinds of provisions that are in wills, from appointing your executor, making them what's called an independent executor so that they can go through that succession independent of some court oversight. And then all of the different kinds of bequests, from the different kinds of leaving specific assets to specific people to just leaving your estate to your 3 children equally. All those important provisions of wills there laid out in Chapter 6 of my book. Chapter 7, protecting your children and your grandchildren. So on the protecting your children side, especially if you have adult children, it's often about making sure that what inheritance you leave them, you make that divorce proof, because yes, the moment they inherit it, like I said before, their inheritance is separate property. But if they mix up or commingle their inheritance with other assets they have with their spouse, it may become community property because of the presumption of community property. And then if they get divorced, they lose a big part of their inheritance. So we talk in the chapter about protecting your children and making your children's inheritance divorce proof. We talk about, to those people who want to carve out things for the grandchildren, the right way to leave an inheritance to your grandchildren to continue to motivate them to be a productive member of society, but give them a little bit of a head start. And so there's lots of different ways to do that. That's Chapter 7. Chapter 8 is about multiple marriages. Really, the big issue there is that common concern where a husband and wife, they get married, maybe later in life, they each have their own children. And the disaster that sometimes happens is, let's say the husband dies and he leaves his estate to his wife. And then after the husband dies, the wife's relationship with the husband's children sours. And so she says, well, my husband left me all of his estate, so I'm just going to exclude his children, even though that's not what we talked about before he died. So there's lots of ways to remedy that, where people who are in blended families or have been married multiple times and have children from prior marriages or relationships, how to engage in the estate planning to not only take care and provide for your spouse, but also protect the inheritance of your children as well. Chapter 9 is about taxes. Not only the federal estate tax, the 40% federal estate tax that really doesn't apply to many people in Louisiana, because the first $13.99 million that one has is exempt from this 40% tax. So we touch on the gift and estate tax, but we also address the capital gains tax, which applies really to anyone who has appreciated assets, maybe a home that's grown in value, maybe some investments or stock that have grown in value. We talk about estate planning for the capital gains tax, the step-up in basis. We describe the carryover basis. We talk about some of the income tax aspects of estate planning. All that's addressed in Chapter 9, titled Death and Taxes. Chapter 10 is where we address usufruct, that unique Louisiana form of ownership, which is really common because it always applies when a married person dies and they have community property with their spouse and they have children. So we talk about what usufruct is, all of the different rules that apply to usufruct, what happens if someone inherits the usufruct of cash versus stock versus real estate versus vehicles. How is a surviving spouse who inherits usufruct accountable to the naked owners? All that's described in Chapter 10, usufruct. Chapter 11 is about living wills. So that's where, if you want to, you can make your decision in advance about life support machines. Many people don't want to burden their survivors with having to make that decision to, as they say, pull the plug. So many people sign living wills. It's where you get to make the decision, usually expressed in some manner like, hey, if I'm in that profound vegetative state, there's no chance of recovery, and the machines are serving only to artificially prolong the dying process. I'm letting my doctors and my family know that it's my desire and my wish, and I'm directing that you honor it. I want those life support machines withheld or withdrawn, but I want to be comfortable. So it's often used to relieve your survivors from the burden of having to make that difficult decision. Chapter 12 is all about trust. It's a big chapter, lots of different kinds of trust. People in Louisiana are using trusts every day, from creating the revocable living trust to avoid that court and attorney involved succession process when they die. The idea there, assets that are in your name when you die, they get frozen, they have to go through the courts, it takes time, it's expensive, it's a hassle. So many people will create what we call their revocable living trust. They'll transfer their assets to their trust before they die. Assets that are already in your trust when you die, they don't have to go through that court and attorney involved process. Makes things much easier for the family. Many different kinds of trusts as well, from putting things in trust for your children or grandchildren before you die, to putting things in trust or leaving things to a trust for a special needs child to preserve government benefits. So all that's in Chapter 12 about trust. Chapter 13 is where we address Medicaid planning. A lot of people have come to me over the years and say, Paul, my mother was in a nursing home and she had to spend all of her assets. So I want to set up my estate. So if I have to go into the nursing home, most people kind of feel like, I don't want to go to a nursing home. I don't like nursing homes, but we never know what the future holds. So if I go to a nursing home, I don't want to lose my house. I don't want to lose all my savings, my retirement accounts. So the Medicaid Planning chapter 13, is we talk about the Louisiana long-term care Medicaid eligibility rules. Since I'm talking quickly here, I will say I really enjoy seeing people plan in advance if you can, to avoid having to use the Louisiana government program that provides nursing home care for the indigent, people who have less than $2,000 to their name. So, but nonetheless, we get lots of questions about it. So I laid out all those rules in the chapter, Medicaid Planning, chapter 13. Winding down here, chapter 14, successions and probate. So maybe you've been through that before, when a parent died, a spouse died, but it's all about describing what happens through the court and attorney involved process when somebody dies and the survivors have to go through the courts to get assets transferred into their name. We talk about getting an executor confirmed. We talk about what's necessary from an inventory of assets. We talk about the steps that are involved and how the courts are involved and how attorneys are involved and how you can make that process more efficient, because it can be difficult and it can take a long time. That's all about successions and probate in chapter 14. Chapter 15, we talk about non-probate assets. So you may have a will or trust that addresses how your estate will be handled when you die, but it's very unlikely that your estate legal documents will address who inherits your IRA, whether it's a traditional or a Roth IRA, who gets your life insurance proceeds, because those are non-probate assets commonly handled through beneficiary designations. So we talk in that chapter all about making sure your beneficiary designations on your non-probate assets are consistent with your overall estate plan. And then chapter 16, we talk about the estate planning letter of last instructions. Some people want to be particular about who gets the china, who gets the diamond engagement ring, who gets the furniture, who gets the piece of art on the wall. And yes, you can kind of clutter up all of your legal documents with those bequests of non-titled items. But a lot of people just like doing that in a side letter. We call it a letter of last instructions, where it's kind of on the side. It may not be a binding document. However, if you clearly communicate what you want your children to do with those things that typically aren't very valuable, but maybe they have some sentimental value, in a letter of last instructions, they'll typically honor it. So we talk all about the validity and the best way to handle those things. And then chapter 17 is just how to get started. So usually involves just taking some action, perhaps making an inventory of your assets, maybe having some conversations with your family, perhaps talking to an attorney about what's needed, and kind of developing a plan and then getting it implemented by having all the legal documents in place. And then perhaps reviewing things periodically in the event amendments or changes need to be made due to life and law changes that may occur. So there you have it, Estate Planning in Louisiana 2025 edition, available only at Amazon.com. Link in the description below. Y'all have a great day.